regulatory, and employment. And we'll talk a little bit more. Our litigation portfolios may be a little bit different from some of the other tech companies.
And as an outside litigator, I've been litigating internet cases for many years. And I remember back in the 1990s, Judge Easterbrook raised the point when many of us called ourselves internet litigators that referring, are technology cases different? And if so, in what way is technology litigation different from litigation surrounding horses?
So I would say that technology cases, it depends on the claim whether you would say that they're different or not. But if for the types of things that we deal with, or most of us deal with on the panel, I would say that they are different, that they're more complicated to explain to the layman, and that includes your fact finder, and that it's complicated in a variety of ways. A lot of us, and even eBay, it's hard to explain exactly what our businesses provide, at least in a layman's way, and sometimes you need to break that down into analogies that might bring some pain with them, but by simplifying it makes it more understandable. And also, this is when you're litigating outside of the bubble that is Silicon Valley. Also, technology cases are the types of cases, the people on this panel probably love to argue about nearly everything, but like nuanced rules, anything, right? That's like our job. That's what we like to do. But if we are explaining what is a typical technology dispute to, family members, cocktail talks, that kind of thing, it's the type of thing that immediately leads to glazing eyes because everything is so if technical or not relatable. And so one of the things you need to do is be able to figure out that story that can relate to judges and fact finders. And sometimes I think for us, the best way to do that is we have close relationships with some outside counsel that understand our business, have been doing our work for us for a long time, and can explain it. Because for example, eBay doesn't, we don't sell anything, we don't make anything, and people don't necessarily understand that. And so the first phone call for a lot of our litigation is typically to the plaintiff to say, well, we know you might have had a bad experience, but you're kind of shooting at the wrong target here. And that's the same story that we have to go carry through. And it's been nice to have some relationships with some outside counsel that can explain that.
What do others think about analogies, translating technology to judges and jurors?
I think analogies could not be more overstated as crucial to winning a good technology dispute. And I've been doing this as a litigator for 20 years and an arbitrator for 2. Look, in the final analysis, a lot of these cases are about ones and zeros flying around this thing we call the internet, right? And it's either a 1 or a 0, the switch is either open or closed. And I really do think that, particularly if you're talking to juries, judges that are not subject matter experts, because they're hearing a criminal case one moment, or perhaps a securities registration case another, and then your case involving a data mishap in the next moment, that choosing the good analogy, the best analogy that suits your case as a litigator, really can make the difference between winning and not winning. And I'll just give you a simple example. As some of you know, I used to be a prosecutor, and I used to prosecute cases as a cybercrime prosecutor, and we used to search a lot of these things, right? And the rules that relate to the search of these types of devices, whether it's on the criminal side or the civil side, they're in flux, and indeed we've had panels at this conference in prior years on those rules. But if you think about it, and you're trying to explain what those rules are, who should be able to look at what's on this thing, under what circumstances, what they should be able to look for, what they shouldn't be allowed to look for, how long they should be allowed to look, you might very well want to use an analogy. And you could pick some good analogies. You could say, well, this thing right here, it's like a big file cabinet, right? It's just like a really big, really powerful steel file cabinet that just has lots and lots of drawers, and the rules that should apply to your search of that are basically the same rules that would apply to the search of a giant multi-drawer steel filing cabinet. You could also say, no, that's quite not right. The rules that should apply to this are the rules that should apply to, let's say, the search of a diary, a paper diary with a little lock and a key and a brass lock, because it really contains a lot of my private thoughts. And that would be a good analogy, right? You could also say, well, actually, both those analogies are wrong. What this is my life. This is a window into my soul. And if you get to look at this, you get to look at and see a lot more about me than anything you'd be able to see inside a file cabinet or a diary. Now, I would suggest that those three analogies are all good analogies. They're all good analogies. But which one you choose and which one you persuade a trier of fact is the right one, I would submit to you, leads to more than 50% of the way in terms of resolving that dispute.
Other thoughts? What about in IP cases in particular? Are there particular issues that you feel distinguish tech IP cases?
Yeah, I do, especially even just at the beginning in the discovery phase. So an IP case, if it's an infringement case, you're not looking for the whodunit, what happened on the street corner and who witnessed it. And let's go look at the hard evidence. You're trying to build a case and build a story that works for your claims or your defenses, and that's a lot different way of going about a case than interviewing the witnesses, gathering the facts, and then putting in your motions. It's really making your evidence, building your evidence in a narrative that works for you and your client.
And just to pick up on Dana's point, when you look at the beginning of a case, when I think of technology cases, it also requires the most heavy lifting at the beginning of a case. In order for you to even be able to assess the strength of the claim, what's going on, you typically have to involve engineers and other folks that understand the technology before you can really dig in to figure out what's going on in the case.
What about in privacy and cybersecurity cases? Because those are also technology cases, but a little bit different from IP cases.
I'll start with that one. It's one of my areas of cybersecurity as well. The thing about cybersecurity is really about what you don't know. Because oftentimes you have someone who's come, they've somehow gotten into your system. You work with your information security team. You think you've surrounded it, really walled it off in terms of their ability to access other parts of the system. And you just never know if you've gotten it all. You never know exactly what's left your system at times, depending on the sophistication of the people that are getting in. And from the legal team's perspective, you're starting to think about any kind of regulatory notice requirements, notice you have to give if there's been customers or individuals who have been impacted. So you hope you've done your best to get that fence around it, but the biggest concern for me is what don't I know?
And just picking up on that, if it's hard to know what the facts are, right, it's probably even harder to know who else besides you might be responsible. Right? I mean, because a data event, a data security event, a data privacy event could be the result completely of something inside your network. But it could also be the result of something at a third party, at a vendor, at a customer, at a client. I mean, really, it's hard to know where your network sometimes ends and someone else's network begins. And so I do think that having expert subject matter counsel, and frankly, if you can, expert subject matter deciders, if you can bring something to a court where you've got a good bench with technology-savvy judges, or if you want to go the route of arbitration, finding subject matter experts who are savvy in these types of cases really can be the difference between bringing a successful case and making a successful case and really falling flat on your face.
So I'm going to throw a little bit of a curveball in. Anybody who was at the platform discussion early this morning, there was a comment there about litigating platform cases and why companies aren't putting themselves squarely in the role of intermediary and trying to wrap that cape of platform immunity or First Amendment protection around them and staying outside the fray, if you will. And I found that really interesting as companies, as tech has become more mainstream, as it's consumer, basically, is what we're doing, can we really, as tech companies, stay in that box from a legal perspective? And what does that mean when we're litigating? And what does that mean for legal strategy? Should we always be putting ourselves squarely in what we consider tech law? Or should we be trying to find a bridge to somewhere else? Could be an analogy factually, but it could also be embracing other legal aspects. And there's a tension between staying squarely within tech law and mainstream law. And I think privacy is one good example where for a long time, privacy has been about cybersecurity and us not being attacked from the outside and what liability falls if we are. We're shifting the direction, or at least companies like Airbnb are, in that we now have a bunch of data. Yes, there are bad people out there that might want to get it, but there are also government entities that want to get it. And what is our responsibility to maintain that data? And so I think there's a bit of a shift in litigating as to what are the standard claims that you're going to see tech companies involved in. Is it always going to be CDA 230, or are you going to see some variety? Mm-hmm. And that's a little bit, a little bit of civil rightsy going on around Stored Communications Act, Fourth Amendment, privacy rights, and what are the responsibilities of companies for that data as opposed to, relying on the ACLU.
Mm-hmm. Bob, I saw you about to...
Well, I agree with the tension and also the shift. I wasn't at the platform presentation this morning, but it's clear that the CDA is under attack, that the DMCA is under active reconsideration. So there's already a shift in the platform space. So you have to look for additional arrows in the quiver, but also it's getting to be maybe untenable from a PR kind of standpoint that just to throw your hands up every time with platform immunity if it means that people are having bad experiences on your platform. So the goal there is to try to make sure that everyone has the best experience that they can. And insofar as that includes, getting more involved in the process than traditionally you might, that's probably on the table, especially given the way that the law is moving.
One of the interesting issues that tech companies, particularly here in Silicon Valley, confront is that there's an assumption, at least within the 408 and 4015 and 510 area codes, that people litigate in a certain way, and there are certain things that are important. And you quickly find that may not be the case in other industries or other places. Dana, what's your experience and what's your thought from a best practices perspective?
Well, we've heard it said already, we're in a little bit of a bubble here in Silicon Valley, and it's something that bears being reminded of from time to time when we litigate against folks that are not in the area. So what I've seen in terms of the disconnect there is, I have assumed in the past that seasoned litigators from top firms in other parts of the country understand basics of how the internet works, understand what an API is, understand just all the things that we would consider standard. But even top litigators and good attorneys at great firms, they don't live and breathe it every day like we do here in Silicon Valley. So they're not meeting with engineers, and they're not talking to product people and hearing how the API calls work and understanding, at least at a very top level, how the systems are architected. So as far as the best practice goes, number one is don't assume other folks understand that, even other seasoned litigators. Or judges, or settlement magistrates, or others that you'll be before. Otherwise, you can end up in a situation where everybody thinks they're talking about the same thing, but they're really not. And so especially in a settlement context, if you're trying to reach some kind of a resolution, if the parties aren't understanding how the world works in a at least fundamentally similar way, then that's thwarted the settlement in the past for me.
The point you made was vividly brought home to me on a handful of occasions, a number of occasions. The most recent one was a few years ago. I was litigating as counsel a B2B data security case in Manhattan in state court, but in the commercial division, which is the kind of the business person's court where just to get in, your claim has to be something like over $500,000. Very sophisticated court. And on our motion to dismiss, I was representing the defendant that had a data security event happen at it, and one of our corporate customers was very angry with us and sued us. And I began my argument on the motion to dismiss, and the judge stopped me and said, well, Sonny, you're going to have to slow down because I don't use email. Right? And it went downhill from there, right? And that's in a major commercial center and a major commercial court. And, I think we forget, the average juror in a major urban center may not have a checking account, right? They may just kind of cash their paycheck at a check cashing place. So even in major commercial centers, your jury pool and even your judge pool can be one that's very sophisticated, but it could also be one that isn't sophisticated. So
I had a similar thing happen, but this is close to 10 years ago now, but I worked for Dell at one time, and we were on a just standard discovery squabble in front of a judge, and motion to compel this and that, and so the other side was asking for a massive amount of document production in overnight. And the judge, we had all our reasons why, and we had the explanation of, well, the servers are here, and and the judge just stopped us and said, but you're Dell, you can do a search. We just weren't going to get there. Right. So, and honestly, the only way that got resolved is, I don't know why we thought to do this, but we brought the junior folks on the team that would have to do the search, and their eyes were already, they had bags under their eyes, they looked horrified at having to do this, and we actually put them up to talk to the judge about what would be needed. Wow. And it was a better communication happened than just the lawyers telling you, instead of hearing from the people that are going to have to go try and do this overnight and aren't going to bed. Yeah, basically.
Yeah, I had a judge in 2018, actually, who stopped me in oral argument and said, but wait a second, can you back up? Can you explain how one sends email on Instagram? So, to your point, Bob.
So the thing I would add to Dana's point is that it comes up in both the discovery context and the substantive defense context, where if you have a consumer-facing business, it's your job to convince the world that it's all frictionless, it's all seamless, it works cleanly all the time. And that's the story, that's the public-facing story. And then you go into court, and either in e-discovery, it's like, okay, well, you're out there, you got a billion listings, of course you can turn this around like immediately. So you have that, so then you already have to backpedal there. But then on the actual substantive defense side, it can actually come into play where you have a plaintiff and a judge who don't understand your business, who then, we just want to make a small little tweak.
Oh, yeah.
Just a small little tweak. Go ahead. And you're like, well, wait, you have to explain everything, and it's just not a great defensive posture. So it's why you have to start at the beginning to educate exactly how it works, exactly what pieces are involved, so that it's not a surprise when, they try to ask for that, and you're like, well, as we've been saying the whole time. And so that might be part of the aspect of, the upfront work, but you probably have to set that up at the beginning of the case, because if you're having that conversation at the end, you're probably in trouble.
Yeah. I don't know how many times I've heard people on the other side say, we'll just throw a pop-up window up there and make the user certified, check a box and hit OK, it's certified, this, that, and the other. And I could see in my head all the people that are back at my company that are going to be mad about that if I agree to that, because it's just going to be engineering sprints and everything else.
And those might be the kind of cases where, again, if you're not before a judge who's going to get it like that, that may be a case you want to arbitrate, or even if you are in a litigation, that might be the kind of case that's ripe for a special e-discovery master to address those issues, because he or she is going to get those issues.
I think the other thing is, for those that are familiar with patent litigation, particularly down in East Texas, this is where I think a lot of us who have done patent litigation really figured out what it's like to get home courted. What we made sure we did, whether I was in private practice or now in-house, is you find the best local counsel that you can, the one that's the most connected to the judges in that district, that are really going to have a good feel for the local jury pool. And I couldn't even begin to tell you some of it, whether it's analogies or just some of the turns of phrases that the counsel down there would use. Whatever it was, it worked. But having them involved very early on, I think is also a really good approach if you're finding yourself outside of this particular district.
And not just Texas. I think that's universal.
Just an example.
People sort of think of it in a backwater of some southern town. That's helpful, but I think it's helpful universally across the country.
Mm-hmm. One of the issues for tech companies, of course, is that you're not just litigating in court, you're often litigating in the court of public opinion. And certainly in the class action area, the plaintiff's lawyers sometimes are less concerned about what happens in court. They're trying to get a settlement by writing something that will be picked up by the press. Renee, what are your thoughts on best practices for dealing with that?
So I wrote I get hit with headlines all day, every day. At Airbnb, it's remarkable. But so I'll give you a couple, which come from absolutely mainstream press. With the San Francisco lawsuit and New York City bill, tensions with Airbnb are coming to a boil. Airbnb smooths over a legal dispute. Airbnb's response to Paris lawsuit is the same old story. Airbnb beats a big property landlord in California. These are New York Times, Fortune. It's amazing to me that lawsuit is super mainstream for tech companies now. And part of that is, it's interesting. Litigation is always interesting, of course. Not historically headline news every time a lawsuit was filed. But tech has moved from being novel to sort of a darling to mainstream and now suspect, right? And so that makes for good press. I still get magazines. I don't know if anybody saw this one. This is San Francisco Magazine from April, and it says, "Can big tech be tamed?" This, I think, that sells headlines. And so when we start to think about litigation is pressworthy at every stage. I mean, it could be a minor order, and sometimes it'll get press. It changes your dynamic from a strategic perspective. And I didn't live through Uber Waymo other than looking at headlines. But I think for all of us that watched Uber Waymo from the outside, the headlines felt super informative, right? Felt like you knew what was going on, and you knew who the bad guys were, and you knew who was going to win that case. And super interesting, the day that they filed this lawsuit, Waymo posted a blog piece on Medium. The title was, "A Note on Our Lawsuit Against Otto and Uber." It's a little understatement. With some details about 14,000 files being uploaded and how much data was downloaded and the wiping of hard drives and really sexy stuff that was in a lawsuit that just happened to be put into a Medium post that day that got tons of press. And ABTL up in San Francisco had a really interesting panel a few months ago with actually Judge Alsup came out and spoke. Arturo Gonzalez was there. Sonali Mitra actually was the moderator. And the really super interesting voice of a journalist who had been tracking this from the beginning. Her name is Sarah Jong. She was writing for The Verge, and she was in the courtroom as the trial started. And she recounted from a journalist perspective this experience. And how at the beginning you thought you knew it was happening, and then as the trial unfolded, it was a little odd. Like, this doesn't seem like it's that big of a deal, and then poof, it was gone magically into a settlement. And so I think it's, I don't know where all the pieces fall. I don't know who was right, who was wrong. It's usually gray. But it's very interesting to think about the power of litigating in the press. And so thinking about best practices, really want to make sure if you have an in-house PR team, that your PR team is connected with you every step of the way. They don't get out in front of you, you don't get out in front of them. You have a gag rule. So nobody talks about open litigation unless they're cleared to talk about it, and that includes your outside counsel. Make sure outside counsel knows they are not free to talk on your behalf, nor are they free to talk as your advisor. Third best practice, write your pleadings with press coverage in mind, particularly your introduction. So if there is going to be press, that's where they're going to lift the line from. And so if they're going to lift a line, you better make sure you're proud if it shows up on the front page of the New York Times the next day. And I'm going to talk a little bit about this before. Bob brought it up as well. But narrative is just so important, especially when you have a light being shined on you, that can carry so much water. You can have the law 100% right, and if you don't have the right narrative, it just doesn't matter. So I'm going to come back and talk about that. I'll come back and talk about best practices for winning in court, which I love to do. But in the PR and the public sentiment, keep in mind who the face is of your company, who's speaking on behalf of your company. And sometimes you don't have a choice, right? But if somebody is going to go out and raise their right hand, make sure they're really prepared. I think people wondered how Mark Zuckerberg was going to do on the Hill. He was super well prepared, including like a little booster seat to boost him up. I don't know if you saw that, which is pretty funny. And they caught it from the side, and they were able to deal with it with great humor. But he was very well prepared. Was he perfect? No, but you wouldn't want him to be perfect. And he carried a lot of water, obviously, for Facebook for his trip to Capitol Hill. So that's my insights.
I agree with everything that Renee said. You know, in the past, it was so easy to say our PR strategy is we don't comment on litigation.
My comment is we don't comment on litigation unless we comment on litigation.
Yeah. Exactly. And these days, particularly for tech companies, you really can't get away with that. It used to be where litigation drove the decisions about what you're going to do in PR. Now I would say that more often than not, for major litigation, PR can actually drive some of your thought process and strategy for litigation. And so I agree, getting the in-house comms team involved at the get-go. Don't wait to turn to an outside press source if you need to, or PR source if you need to, if you don't have it in-house. The other thing I'll throw out and then see what others have to say is social media. And I mean this also for your employees. So we've got 22,000 employees globally, and sometimes they might become aware of a piece of litigation that's going on, and whether they agree with it or not, they may start making comments. And the next thing you know, you're getting a deposition notice for that employee. So another thing, to the extent that you can, is communicate internally with your employee base, particularly those that touch whatever the product is or the solution is that's at issue, and make sure that they understand what their obligations are as an employee as well.
I would also add to that, in addition to having all your folks teed up, you're going to have to if you're a plaintiff, you're going to have to decide, am I going to court? Where am I going to court? Am I going to seek to arbitrate this? If you're a defendant, maybe you have the option to remove to a specific court or to arbitrate if there's an arbitration clause. If you're a big company that's regularly litigating, you probably have already thought about what jurisdictions are the best for you and the worst for you. And I would suggest that even if you're not a big company, you should think about that too, down to the level maybe of even figuring out what are the sealing rules and the practices of a local district court as it relates to the filing of documents under seal, right? Because it's easy in an arbitration. Arbitrations are confidential, they're private, you can tie them up as tightly as possible with protective orders and really batten down the hatches quite tightly. But different courts around the country have different rules about what can be filed under seal, what can't be filed under seal, and even just local practice and custom about what's allowable to be filed under seal and what's not. So again, I would think that the big companies have thought about these things already, but even if you're a medium or small company, it's a great summer intern project, right? I mean, we're at the beginning of the summer to just figure out some of those things for the times when you'll have a choice, right? Oftentimes you don't have a choice, but sometimes you do.
One of the interesting questions also is who is your judge, and Brooks touched on it in terms of the Eastern District of Texas and the importance of having local counsel. I know during the time that I've practiced, things have changed quite a lot in the federal system, in that judges stay on for a much shorter time. When I started practicing law, life appointment typically meant for life. And now it's much more common for judges to get on the bench, stay about 5 years, and then retire to do ADR or to go to a company or do other things. And so there's a much bigger turnover. And we saw that where at a certain point in his administration, George Bush was responsible for the largest single number of federal judges. And then at a certain point in his term, President Obama was responsible for the largest number of judges in the federal judiciary. So the turnover is great. And we also see increasingly that we're getting more liberal and more conservative judges appointed by each successive administration. So What I find is that it's very important to know who your judge is, and in the world of big data, you now can get all that information pretty quickly. Obviously, you can't extrapolate exactly, but I had a case recently where we had predicted to the client that our motion to dismiss would be ruled upon in June, and like clockwork, the judge gave us the right ruling in June. So although you can't extrapolate, there actually is a lot of information you can get from big data, and knowing who your judge is impacts to a greater extent than I think in past years what your strategy is in the case. What are you finding from an in-house perspective on that?
So what, like 10 years ago, all you had were the 3-page bios that had some local practitioner with a quote about the judge that was sufficiently vague enough that could play either way. And so your experience, how you decided on your judges back then was just strictly based by the outside counsel's experience and the network that they had so that they could figure it out. Right on the big data side now with like Lex Machina, it's exactly that. It's not you can see how long it takes them to rule, whether they rule, and so it's not only like how many do they decide against or for, but you figure out like the life of cases by category for these judges, which I think are much more informative for the kind of decisions in-house wants to make, because you're thinking about how much is this going to cost and where you're going to see your expense over the life of the suit. It's a lot easier to do with the data we have now than what it was.
Yeah,
most people know what Lex Machina is.
Started here at Stanford.
Okay.
But that doesn't mean everyone knows that.
Two other quick comments. One, when I think about big data as well, is I've also found that most firms are incorporating that into their pitches. So, lawsuit's been filed, you know what judge you're in front of, or at least what district you're in. And I actually find it quite helpful even at the pitch stage for people to bring that information in. And I'm also just a big believer in going and attending significant hearings and trials for a particular judge. I kind of want to see it myself still. So I still think that's one of the best tools you can use is, if you know a case is going to be going to trial starting 8-9 months out, keep an eye on the docket and look for that trial that's coming down the road that, looks somewhat similar to yours.
And what about jury consultants? What are your thoughts on those?
I hate jury consultants to pick a jury. I think it's a waste of money. It depends jurisdiction by jurisdiction, even how much voir dire you're going to get, right? So I think that I have a very strong opinion about them for that purpose, but I do think mocks are very helpful. I tend to mock before trial in some version of a mock. I almost always do that. Mm-hmm.
I know some courts are starting to impose rules, some of them written, some of them not written, advising jurors about the possibility of deep social media research on them. And I'm aware anecdotally of a few instances in kind of the Northeast of situations where right up front when the panelists first brought in the big panel, the judge will say, and of course he or she has told us the lawyers before, if you plan, counsel, on doing social media research about any of the prospective jurors, I'm going to let them know that they should expect that both sides will be conducting deep social media background research on them. And it's interesting that according to the judges that have told this story, about 3 or 4 now, in about half the cases, counsel have, upon hearing that, refrained from doing deep social media searches. In about half, they've gone ahead anyway. So, because you can imagine a juror just being a little put off on that.
I think I went too quickly on jury consultants. For voir dire purposes, I do think questionnaires are helpful. I think digging into whatever is going to be available. Sometimes you're seeing a jury after half a day, right? It's in, out, you're going. And sometimes they'll let you do voir dire for, feels like weeks. So I do think it's interesting, but you can get bogged down in focusing on processing all of that data as opposed to getting a jury seated and actually putting your case on. And I think sometimes your voir dire can have your jury prejudging you. So it's like another show before the show. But I think the social media piece is super interesting, and I don't know if I were sitting as a judge which way I would swing.
It's hard to know.
Well, the group wanted to also talk about best practices for winning motions and trials. And let me just say, as outside counsel, I found clients do think that winning is a better practice. That losing is not a good practice, and if that's in the cards, unless the client's totally on board, settlement may be the next best practice. But Renee, what are your thoughts on, in a more serious vein, about best practices for winning on motion or in trial?
So I think we've hit a bunch of them already. Leave the bubble. You got to leave the bubble. Even if you're in the Bay Area, you need to leave the bubble and know that your audience is not tech. That is the translation feature that we've talked about. Knowing your audience is super important. So why should your audience, whether it's judge or jury, care? At the end of the day, whether they're looking at a motion or they're looking at deciding your entire case, why should they care? And if they should they care for you? What kind of benefit are you providing? Are you acting as a good actor? Who should bear responsibility? All the values questions, that's what causes people to make judgments. It's very rarely cut and dry on the law. People make a decision about what they think is right. That's what judging is. And so for me, my team always has heard me for all the years I've practiced talking about winning the hearts and minds. You absolutely have to have the law right. Of course you do, and that's the mind part. But if you can't grab the heart too, then you're not going to carry the day. And so the narrative becomes so important of trying to connect with your audience, make them care about you and your cause, and come to the right conclusion. I think the use of visuals, I am not a big fan of reading super dense prose for 25 pages. I don't know who is when they have volumes of pleadings in front of them. So I like to punch it up, whether it's indenting, whether it's charts, whether it's sticking visuals in there. Sometimes I've submitted CDs with video. I used to work for a gaming company, so we put some gameplay in. Any type of demonstrative, anything you can interact with, just spice it up and make it interesting, so that's one way to make somebody care. And then I'd go back to who's the face. So I spend a fair amount of time thinking, if I'm going to put a witness up and they're going to raise their right hand, is that the right person to be the face of the company? Are they going to succeed? Is it going to be a miserable experience for them? Because if it is, that's going to be a miserable experience for all of us. They won't be able to connect with judge or jury. But also, can they deliver the story? It doesn't matter. I won't say it doesn't matter. It should matter less what a lawyer, what Ian, when he stands up and gives an opening and closing, that's not evidence, right? That's what we've all been taught. That's not evidence. The only thing that's evidence is what comes out of the mouth of the human being sitting in the chair. And if that person has the credibility and can tell the story and carry your water, then you've done your job. So picking witnesses and not being scared of evidentiary hearings, because I think they're super powerful, is, I guess, my last piece.
I would just add, that's a great list. I would add preparation. It does start way back before trial. And, when you get into that courtroom, which is the team that operates seamlessly, that just looks like there's not a care in the world in the way they operate. And then, you can't forget about the diversity of your team as well. And that's both the team that's putting together your case to bring all those different perspectives as you're preparing your case, whether it's the offense or defense, but it's also the group that you're putting in front of that jury, because you can rest assured that jury is going to be diverse, and you want to make sure that your team is able to connect with them.
One piece I'd add to that, we had a trial in Marshall, Texas, and I made the decision to have, it was a big case, and I had lots of lawyers, but there were 3 people at counsel table, and they never changed. There was no revolving door. Those were our trial lawyers, that was the team, and that's all the jury saw in front of the bar. And they had a lot of consistency, and they built credibility. The other side had lawyers cycling through all day. People would be popping up in the middle of testimony. There was no consistency from witness to witness, and we ended up winning for lots of reasons, but I think it was also part of it, is if you're going to trial, have a trial team.
I would just add, and I'm now seeing this both as a litigator and also as a neutral, as an arbitrator deciding these cases. I've really been impressed the more I'm doing arbitral work as an arbitrator, how important the lawyer's tone and credibility is to me as a decision maker. We're not, as counsel, put in the witness box and sworn, but it really is the case that every encounter that we have with a trier of fact, whether there's a judge or a jury or an arbitrator, every encounter our credibility is on the line, right? And what that means to me as a litigator is number one, appreciating that, but it also means being sure that I've not only prepared incredibly well, not only figured out my judge and whether he or she likes things in paper format, or maybe that judge doesn't like things in paper format, right? But it also means understanding that in the end, the judge and the jury, as much as they're going to be judging the credibility of the litigants and the witnesses, they're also going to be looking at my credibility as a litigator. And when I was prosecuting cases, I was a prosecutor for 10 years doing cybercrime cases. One of the cardinal rules that we always followed at the U.S. Attorney's Office was, don't hide the warts, right? Front your bad stuff, get it out there, because as bad as the wart is, it's going to be infinitely worse, right, if it's been put in front of the trier of the fact as a surprise to you or as a surprise to the trier of fact. So think about your credibility. Think about, sometimes leading with your warts, while at the same time being mindful of the press and the story that's going to be told, and just really understand that, particularly in the context of a bench trial or an arbitration, the tone and your credibility are going to be part of that, whether you like it or not.
And on building credibility, particularly before in an ADR setting, I think it goes a really long way if we can be reasonable. It sounds like table stakes, right? But just being reasonable where you can, so it's not a knockdown, drag out fight. It's going to be me or you that walks out of here kind of a day. If it's more like, look, they've asked for this, we can do that. Mm-hmm. I think that buys a lot of credibility, and then I've felt it in cases where that credibility that you buy sort of turns the neutral into your friend on the other side. And so you can kind of turn them and get them helping you in the other room.
One thing for in-house, if you feel like you've got the wrong team, or if you have a team that's litigators but not trial lawyers, be brave and know sometimes you have to switch out a team. And it can be painful, but it can mean the difference between winning and losing. I had to replace a team for trial 6 weeks before trial, and the prior team had been litigating for 2.5 years. But I knew if we went with them, we were going to lose. Sometimes you have to make some really tough calls in-house.
What about discovery, which is
we hate it. Don't talk about discovery.
Discovery these days actually can be, in many cases, the most expensive part of the case, more expensive than trial. But you're right, everyone hates it, and the higher you rise, the less you have to pay attention with the discovery. But it is obviously quite important. Brooks, what is your thoughts?
Everyone hates it, so it comes to me. This works. Discovery is complicated. It's always about right-sizing the approach that you're going to take to discovery. You're not going to run out every ground ball on every matter that comes across your desk, whether it's a small employment matter or a small licensing dispute, versus the big IP cases. So, being thoughtful about right-sizing and the approach that you want to take. I'll start off with 2 best practices and see what the others have to add. One is I want you to think about being transparent particularly during the document collection and production process. And by that I mean being very open with the other side in terms of where it is on your network that you've searched and looked for documents. What are the search terms that are going to work? When they give you a big long list, run that list. See what kind of hits you're getting, and when you get 1 million hits on a word, tell them, no, that's too much, for the size of this case. If you take that approach and you end up in a dispute, then consider taking that dispute to the judge. Because if you're doing that on the front end, you're going to be much better situated if you want to do either cost sharing or cost shifting, and the rules provide for that. It's much more difficult to make a cost sharing or cost shifting argument if what you've done is stand on objections and then wait until that dispute gets taken to the court 5 or 6 months after it was that you're supposed to have completed that production. So if you take that transparent approach at the beginning, it makes it very difficult for the other side to make a colorful argument that they shouldn't be on the hook if they're asking for too much. So that's one piece. The other is, make sure that with your litigators in particular, that when you're thinking about trial for cases that have a prospect of getting there, that you take trial-ready depositions. And by that I mean, most litigators go in, even sophisticated partners will go in, and it'll just be exploration. They're just trying to search for the facts to figure out what's going on, but not really thinking about how might I use this particular depo transcript or video at trial. And we had a trial about a year ago now. You mentioned Arturo Gonzalez at MoFo. The guy's he's an amazing trial lawyer. And we had him take the majority of our major depositions in this case. And on the other side, our adversary had a senior partner doing it as well, but they had a very different approach. Arturo took the approach when he was asking questions as if that person was on the stand at trial. And the video clips he was getting, 2 years before trial started, we ended up using at trial. And it was night and day. Because what typically happens when you get to trial is for every witness who's not going to be presented live, each side picks out portions of that transcript that they want to use. And one side is struggling to pull something out that the jury can digest because it's just exploratory. There's not a lot of meat on the bones. In contrast, Arturo's done this, cross-examination of the person, and so it's just very compelling in that moment. So I'll see what others have.
So on that point, I mentioned mock trial. If you get to mock trial and you do not have any deposition testimony that you can show at mock trial, your outside counsel didn't do a great job at depositions. So one best practice is, as they march through depositions, I don't want deposition summaries. That's craziness. What I want is the questions that came out of that deposition that we'll use at mock trial.
And with the possibilities that are out there to do mock trials, you can constitute a trier of fact and do a mock trial that bears remarkable resemblance to the court that you ultimately are in, if you're in a court.
Absolutely. What about mediation and arbitration? Obviously, there's a big push for ADR in the class action area. If you've got privy to contract and arbitration provision, you're hopefully not litigating. Joe, for 2 years now you've been doing that. What are your thoughts?
So I'm seeing a rise in it, and those can, relative to the topic of our conference today, those can come up both in a number of contexts. They can come up in the context of the back end of a B2C data breach. So there could be a data breach that happens, it's a B2C data breach, and at the back end of that, the entity that was sued by plaintiff's class counsel may have a cause of action against some other business that was responsible. So that happened in the Wendy's case. So Wendy's had a point of sale terminal breach, a lot of credit cards were stolen, and a number of banks that were forced to reissue the cards then sued Wendy's for similar allegations as alleged by the class. It can also happen in cases between businesses. I see a lot and increasingly of situations where, as between two companies whose networks are stitched together and data is always leaking out and malware is always leaking in, those businesses are increasingly holding each other accountable and responsible for what happened between those two businesses. It's also happening in the insurance context. As most of you know, the insurance industry is writing huge amounts of coverage across a wide array of conflicting policies. And following data incidents, entities that are covered are bringing suits or disputes to recover claims. So I'm seeing it there as well. I think the key point is, and the key takeaway is, regardless of where you're going to bring that dispute, I do think it behooves inside corporate counsel to think about, and outside counsel as well, not only kind of what the best court is, but whether or not it's something that should be arbitrated, and also whether it's something that should be mediated. And a good focused mediator who really gets the parties before them to boil down their case to its essence can be a tremendous, in my experience, benefit to both sides, even absent situations where the case is completely resolved by that mediator, right? It can give the parties a clean, neutral, hopefully you pick a subject matter expert in your relevant to your dispute, assessment of the strengths and weaknesses of their case. And that can only help you, I would think, in most cases, to either settle the case or, if you do go to litigating it in the best proper way with your best trial team.
What about the timing for mediation? There's a retired federal judge, well-respected, who mediates, who I know has said to me, he thinks there's never a good time to mediate, and so really any time you should come to mediation. And of course, as outside counsel, I disagree. I think in every case, I see that this is a case either that we don't want to mediate because we want to win, or that it would be right at a certain juncture. But, what are your thoughts? Is there really no good time to mediate, and so should you always mediate?
So I'm a fan of mediation up front. I think sometimes you want to sue. Sometimes you want to be in a lawsuit and you need to get things resolved. But if you're really trying to resolve a dispute as opposed to have a lawsuit, vast majority of times, mediation gets it done. And so, to me, I like that gate. Like, let's go. Let's have a professional facilitator put down everybody's arms and try and have a conversation. And you might get a little bit of free discovery, and since I hate discovery anyway, I like free discovery. But I think it is worth the time and the expense at the beginning.
I think any case that I want to mediate, the other side doesn't want to mediate. Any case I don't want to mediate, they want to mediate. So timing is usually driven by external factors, either the court deadlines, required mediation, or certain breakpoints during the case that both sides recognize are either going to run up the price or at least clarify the issues. So that's okay, and that's a way to get people to the table. For most of it, I would prefer earlier so you don't spend more, but seeing as how most of the people who sue us are just trying to cost us money anyways, that's the significant amount of their leverage. It's hard to sell them on that as a reason to go to mediation.
I think it makes sense to mediate a case, not just to mediate, but when there's an articulable reason to, right? You think that it has a fair shot to dispose of all or most of the dispute. Or, if you're a plaintiff, you want to perhaps use it to shape and craft the best version of your argument as possible, and in a sense, road test it in front of the mediator. But there always should be an objective. It shouldn't just be done for the sake of doing it. Although some courts require you to do it, and then you're stuck.
I think part of it's also a mindset. If you go into it with creativity in mind, and obviously it depends on the context. If you're going against a competitor or the like, part of it's just that mindset, going in and being willing to look at creative solutions. One thing to think about, if you do view a particular case as having a potential business solution, one thing to think about is don't have your lead litigator run that mediation for you. Bring in someone from the corporate team from that firm, someone who's going to have a bit more of a business-oriented thought process. It doesn't mean that the litigators don't support it and you don't have the discussion around the merits of the case, but if you're really looking for a business solution, sometimes taking the litigators out of the mix can be helpful.
What about best practices for dealing with outside counsel?
So obviously I have a lot of thoughts on this, not a lot of time, but one of the things I wanted to hit on this is building on a point from earlier, which was discovery, and how discovery can be the lion's share of your spend on cases. Something that we've been very successful is in-housing the e-discovery function. So we have a team that collects, that processes. We have in-house tools. We're able to do ECA in-house now. They're great on information governance and being able to establish, repeatable procedures that help defend us in litigation. The key for dealing with them, combining them with outside counsel, is then making sure that whoever our lead litigation shop knows how to work with them, and if we use a review shop, knows how to work with the review shop. So like when I'm talking major big litigation that's going to have some significant discovery doc review, the key for me on managing outside counsel is finding that counsel who knows how to leverage those other resources without it becoming a churn fest where everyone's doing the same thing. And I've had some that are successful and some that are less successful. So the other thing I would say is learn from that and move on.
Others?
For me, it has to be a partnership. You have to figure out a way to make it work for both us and our counsel. And I find that if you establish those relationships, you've got good communication channels open, you're less likely to run into problems going forward. I also find that it's helpful if you explain to outside counsel what the pressures are that you're under inside. So, for example, it might be, with your finance department. Sometimes outside counsel doesn't understand that coming in under budget can be just as bad as coming in over budget. If you come in under budget, we weren't able to hire that engineer to get that new product out before the end of that quarter. So explaining to outside counsel what the pressures are that we're under in-house, they actually become an advocate for you, and they start looking for those issues in advance of them ever popping up.
I would add that not all in-house counsel are the same, obviously, and so litigation style varies from person to person. So putting up front to your outside counsel team what your particular style is, what your level of involvement is, what your expectations are, and how you operate, kind of eliminating surprises and setting expectations that are very personal. I think litigation is very personal. That's really a key to success. And then, if your styles don't match, again, sometimes you have to move on.
Especially in risk tolerance, right? Because it can drive the overall strategy for the whole case. And if your outside counsel doesn't align with you on that, it can be a process of trying to re-educate throughout the case. But if they kind of get it out of the gate, you can kind of short circuit some things. I think that's really important, and that's why for a lot of outside counsel relationships, they're long and they take work because you want them to keep understanding where you're at.
So we're out of time, but if anyone has a quick question, we can field that. This has been by far the most polite audience, taking notes, not jumping in. But if anyone wants to come forward with a question or come up privately and afterwards, thank you very much. It was a great panel.